As you mentioned, today's episode is about CUE claims. What is a clear and unmistakable error claim in the context of VA disability benefits?
Sure. So VA disability benefits are legally quite different than lots of other civil proceedings. One of the ways that they're different is that in most systems, once a case has been decided, it's final and that's the end. So for example, if you have an auto accident and you're not able to resolve the claim with the insurance company and you go and have a trial, once that trial is over and the appeals have been resolved, generally speaking, that result is final and can't be changed. Whether it's a good result or a bad result, that's it. You're stuck with it.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Hello there. Welcome to Victory Over VA, your guide to unlocking your VA disability benefits. So welcome to today's show. We're going to talk about CUE, which is an acronym for Clear and Unmistakable Error. So who are we? Well, I'm Francis Jackson. This is Christian Terrison, and we're from Jackson & MacNichol, a law firm that specializes in getting justice for veterans on their VA disability benefits. So what's this about? Well, as I said, today we're going to talk about clear and unmistakable error. And who is this show for? Well, this show is for veterans, but it's not just for veterans. It's for those who are concerned about veterans, whether you're a spouse, a relative, a friend, or just someone in the community who wants to support our veterans. These podcasts are intended to give you the information to effectively help veterans with their claims. So without further ado.
All right. So, as you mentioned, today's episode is about CUE claims. What is a clear and unmistakable error claim in the context of VA disability benefits?
Sure. So VA disability benefits are legally quite different than lots of other civil proceedings. One of the ways that they're different is that in most systems, once a case has been decided, it's final and that's the end. So for example, if you have an auto accident and you're not able to resolve the claim with the insurance company and you go and have a trial, once that trial is over and the appeals have been resolved, generally speaking, that result is final and can't be changed. Whether it's a good result or a bad result, that's it. You're stuck with it. But in the VA system, it doesn't work like that. And it's probably helpful to talk about a couple of different ways it doesn't work like that. So say, for example, you make a claim today for VA disability benefits for your back, and the VA turns that claim down, and you appeal, and you exhaust your appeals, and you still get turned down. In most systems, that's the end. But in the VA system, you can come back 10 years later and seek to undo that result in a couple of ways. And the way we're talking about today is clear and unmistakable error. And what that means is if you show that you presented evidence to the VA that demonstrated that you were entitled to benefits and the VA improperly turned you down, you can go back years later, decades later even, and raise the issue of whether the VA's determination was so far off the mark that it was clear and unmistakable error. For example, say that the VA sends you out for an examination, their examination, typically called a compensation and pension exam or C&P exam, and the examiner says that you have a mental health condition caused by your service, but the VA turns you down on the claim. And the VA turns you down because they say there's no medical evidence that you have a mental health condition related to service. Now, if that doesn't get sorted out on appeal, and sometimes it doesn't, you have the option of going back later on those facts and saying the VA's failure to recognize that the examiner found a connection between your current mental state and what happened in service and wrote a favorable opinion, the VA's failure to recognize that was a clear and unmistakable error, and you can seek to reopen the claim on that basis. The thing about clear and unmistakable error that it's important to understand is it's a very tough sell to prove clear and unmistakable error. You really have to have almost the VA saying black when it's white. I mean, it has to be very clear that they made an error. And certainly there are cases where that has happened. We've had cases, other people have had cases. There are reported cases where the court found CUE, but it really has to be clear. It has to be really, really clear.
So clear it's unmistakable. You might
Exactly.
say. Well, so how does a CUE claim differ from other types of appeals in the VA disability system?
Well, in most VA appeals, you're talking about a situation where the evidence is in what they refer to as equipoise, meaning that the arguments for and against the claim are at the same level, or the claim for service connection is stronger. But as one of the judges on the court early on said, this is like baseball, the tie goes to the runner. So if the evidence supporting the claim is as strong as the evidence against the claim, then the veteran is entitled to win. But that's how an ordinary appeal gets judged. With clear and unmistakable error, it has to be so bad, the decision you're attacking has to be so bad that any reasonable person reading it would say, they got this wrong. You know, if a fourth grader reading the decision, once he learns the content of the vocabulary that's being used, could say, this is just wrong, then you might have a winning case. But if it's not really clear, then you're going to lose on those. Those are very tough cases to prove.
Well, I guess by way of illustration, what are some examples of, errors that reach that clear and unmistakable level?
Well, we have had a case years ago at the court involving a fellow named Moody, Robert Moody. And the issue in his case was that he had been found to have a condition called prostatitis, but the VA simply ignored the fact that he had some mental health issues that were being caused by or were related to his prostatitis, and kind of slid by that. And we went back and said, no, that the evidence was there, it was clear, the VA had simply ignored it, and ultimately won that case, proving that. But I have to say that, we've had some cases where I thought we were going to be able to establish clear and unmistakable error, and we were not successful. It really has to be almost black and white. We had another one where the VA ignored the fact that the gentleman had a medical board put him out of service for his knee. The board said that this was a pre-existing condition. They have an acronym, EPS, existed prior to service, and sent him on his way. But there was no evidence that he had knee problems before the service. And when we went back around, we were able to demonstrate that the VA had improperly relied on the board, which was unsupported by the medical evidence. Even though it's theoretically a medical board, they had no evidence to support the notion that this condition existed before service. But it's a very rare case. I mean, the purpose of the very existence of the clear and unmistakable error doctrine is just to correct truly egregious errors. I mean, if the error is not blatant, then it's probably not going to be correctable on a claim of clear and unmistakable error.
And if you do have a successful Q claim, what happens? What's the outcome?
Oh, that's very significant. If you win a Q claim, no matter how far back the decision was, the new decision saying that, in fact, there was an error that changed the outcome and the outcome is now being altered because of that, that new decision goes all the way back to the date of the original denial. So if you show that there was CUE in a claim in 1968, the award of benefits will go back to 1968. I mean, it is a very powerful tool when you can bring it to bear. It's just one that's very difficult to use.
When filing for a CUE claim, are there differences from how you would make a claim, just a regular claim for a disabling condition?
There are. For the last, well, not quite a decade, but for a number of years now, the VA has required that if you make a claim, it has to be on a specific VA form. Depending on the claim, there are different forms it has to be on, but most typically a 526EZ for a new claim or the 0995 for a supplemental claim. But it has to be on that form. There is no form for clear and unmistakable error. And so it's a motion to revise a prior determination. And it kind of comes in two different flavors, if you will. Probably more common are motions to revise a regional office determination for clear and unmistakable error. But you can also apply decisions by the Board of Veterans' Appeals. So that's the other type, if you will. But in either event, it's a motion to revise the prior determination based on clear and unmistakable error. You have to explain what the decision was, what the clear and unmistakable error was, and critically, and the reason why so many of these fail, is that you have to be able to show the error based on the information that the VA had at the time of the decision. So even if there's all this wonderful new evidence that came along after that decision that shows it was wrong, that doesn't count. It has to be based on the information that was in the record before the VA decision maker at the time of the decision.
Gotcha. So that makes sense logically. You can't bring any, hindsight being 2020, can't bring anything new to the table. So you really have to look at what the VA considered at the time the decision was made if you want to prevail on a CUE claim.
That's correct. Now, there are other ways to change the outcome, if you will, of an adverse decision based on new evidence. You can go back and reapply and say, look, I really do have a problem with my back. Here's all this new evidence that shows that I have the problem with my back. It's related to service. And that will undo, if you will, the denial of benefits. But it won't let you go back to the time of the original decision. It will simply give you benefits from the time you submit this new evidence and new claim.
And is it evidence that, limited to evidence that the VA had in its possession at the time in considering the decision, or is it if you can show that they should have had evidence that existed at the time, would that be sufficient for a Q claim?
Not for Q, no. For Q, you've got to show that they had the evidence in front of them and they got it wrong.
And they still got it wrong.
Yep. And that's why these are so rare. Successful Q claims are extremely rare. But, you know, it's a very powerful tool if you have the facts to support it, because you can literally go back decades.
And are there any time limitations or deadlines associated with the CUE claim?
No, there are not. There are a couple of things you have to kind of watch out for. If you're asserting CUE in a Board of Veterans' Appeals decision, you only get one crack at that. So if you're arguing CUE in a board decision, you need to make sure that you've really sat down and thought about every possible variation of CUE that could possibly exist based on this board decision, and you raise them all, because you only get one shot. Whereas with a regional office decision, you can make multiple claims for revision based on CUE, based on different theories or different errors by the VA in that one decision, but not with board decisions. With board decisions, it's one and done.
And in the context of a CUE claim, where do, I guess, medical evaluations or expert opinions fall in the mix of supporting evidence?
Well, they can be quite powerful. I think I mentioned early on that if the VA has a medical opinion that demonstrates the condition that currently exists was in fact related to service, and the VA nonetheless denies the claim, that can be a basis for CUE. But what you have to watch out for is, say the VA has 5 medical opinions, and 2 or 3 of them, or 4 of them, or even all but 1 of them say that there is service connection, but there's one that says it's not. The VA, assuming they offer some valid reasoning, can adopt the one that says that it's not connected and reject the others. It's only when you have undisputed medical evidence that they overlooked or ignored that you can use CUE. I mean, if it's simply Well, Dr. A says you should be service-connected, and VA Dr. B says you shouldn't, and the VA goes with Dr. B. That's not CUE. That's the VA weighing the evidence and deciding which one they think is more probative.
Okay. Are there any recent legal changes or precedents that impact how CUE claims are handled or decided?
Oh, no. The CUE is pretty cut and dried, really. But there is a recent decision within the last year or two from the Federal Circuit that involves CUE and established that when you make the determination that CUE occurred, then you look at the subsequent pattern of the claim, and it has to be adjusted to match the CUE. And I'm not saying that particularly clearly, but in that case, for example, the CUE occurred a number of years ago, and had that decision been implemented properly at the time, the veteran, this is a case brought by the spouse after the veteran's death, but the veteran would have been entitled to payment at the 100% level from that point forward, and was not. So the court basically said that you have to go back and factor in that determination in terms of how the subsequent claims should have been treated, so that the benefits should have gone back in a larger amount to an earlier date because of it. And I'm sorry, I don't remember the name of the case offhand, but it's a good case and kind of lays out how all this gets applied. But the basic rules of CUE were pretty well hashed out by the court early on and haven't changed.
And, as you're aware, the appeals process for veterans' claims can take years. What impact would there be, or what factors would a veteran have to consider if they're in the midst of an appeal and they think they've spotted a clear and unmistakable error in a prior decision? Can you pursue both the regular appeal and then start a CUE claim as well?
Yes, those move independently. The hard part is getting the VA to act on the CUE claim. They're notoriously slow about deciding those. But yes, you can have multiple claim streams moving forward at the same time, including a CUE claim, but there's no barrier to that.
Okay. And what would your advice be to a veteran who has spotted, an error or a clear and unmistakable error in their claim history and wants to make a CUE claim?
My advice in those circumstances would be to get expert help. CUE cases are notoriously difficult to shape in the correct way to present them to the VA to win. So many CUE claims get turned down, and sometimes, unfortunately, it's not because there wasn't CUE, but simply because it's not being presented in the right way. I would encourage anyone with a CUE claim to seek help from an expert, preferably an attorney with a lot of experience with CUE claims. Those are exceedingly difficult claims to win. And as I mentioned earlier, one of the problems is that if it's a board decision you're seeking to establish CUE, you only get one bite at the apple. And so you need to make sure it's the best possible presentation, particularly if you're talking about a claim that potentially generates years and years and years of back benefits if successful. I don't often say that people should get expert legal help in their VA claims. Certainly, many claims can be presented effectively by the veteran himself, but CUE is so difficult. I encourage anyone who thinks they have a valid CUE claim that will potentially generate a significant amount of benefits to get truly expert help on that.
And on that note, that's our episode for today. Thank you for tuning in to Victory Over VA. Please be sure to like and subscribe and join us next week.
We'll hope to see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.